Thank you, colleagues. We will recommence. We move to Group 8, Provision of Approved Substance and Device. I call Amendment 90 in the name of Sue Webber, grouped with amendments as shown in the groupings. I draw members to the procedural information in relation to these amendments as set out in the groupings. Sue Webber to move Amendment 90 and speak to other amendments in the group.
Thank you, Presiding Officer, and I move my Amendment 90. And I will speak to Amendments 90, 96, 134, 135, Amendments 213, 215, 216 and 217, 217, Amendments 99 and 100, and Amendments 106, 122 and 124. So I've got quite a few in this group, as you can tell. Taken together, these amendments are really just there to attempt to clarify several areas of the bill where significant uncertainty remains. Firstly, Amendments 90, 96, 134 and 135 concern informed consent, and we have heard a lot about consent. They require that a registered medical practitioner clearly explains the risks, the side effects and the uncertainties associated with the substances used to end life. And that includes the possibility of complications or that the substance fails to cause death. Evidence from jurisdictions where assisted dying operates shows that these substances can involve large quantities of medication, unpleasant side effects, and sometimes requires anti-nausea drugs simply to keep them down. And in a small but significant number of cases, the drugs do not work as intended. In other words, do not cause death. If this bill is to proceed, it is surely essential that patients are fully informed of these realities. Second, my amendments 213, 215, 216 and 217 address the ambiguity around self-admission. Yes, I will, Mr Hepburn, if we're going back a bit.
Thank you, Webber, forgive me. I do have some sympathy with the points that are laid out at Amendment 90. But I do note from the government's note that's shared with us, there is a challenge around prescribing adequate time being allowed for a person to consider and ask questions, but not defining what adequate time means. Clearly, we're looking at something put in law here. Is there anything laid out within the bill that she thinks could prescribe for what an adequate time would actually mean?
This whole bill is full of ambiguity, Mr Hepburn, and there's not a lot of clarity in much of it. But I think what we do need to do is make sure that patients that are perhaps considering an assisted death, which is not something I would consider, are given the stark reality of what the process entails. We'll hear, I'm sure, about some dignified deaths, but not about the unpredictable reality of what administering these life-ending drugs might mean. Can I move to my amendments 213, 215, 216 and 217, which address that ambiguity around self-administration? And they're there to make it clear that no physical assistance can be provided at the point the substance is taken. Without clarity, there is a risk that what is described as assisted dying could, in practice, move close to clinician-administered euthanasia. And these amendments, therefore, attempt to protect the central claim made by the bill's sponsor that the final act is undertaken solely by the individual. Third, Amendments 99 and 100 deal with what happens if the approved substance is not used, and they require the immediate securing, return or destruction of the drug alongside written documentation. And given the potency of these substances, the bill should clearly address the risk of diversion, misuse or unsafe storage. And I was pleased that one of Mr MacArthur's amendments in the last group didn't pass. Finally, Amendments 106, 122 and 124 relate to reporting complications. Because there are complications, and provision of a lethal medication within the NHS is going to place us into entirely new territory. If complications occur, particularly where distress or prolonged death is involved, it is vital that this information is recorded, analysed and reported to Parliament so that meaningful oversight is possible. We have to understand people are individuals and they all interact and respond to drugs in a very unique way. So taken together, all of my amendments highlight the number of practical and clinical questions that frankly remain unresolved in the bill before us. Thank you, Presiding Officer. Sorry, Ruth Maguire. I would have taken it if you jumped up a wee bit earlier.
Thank you. I will just take this moment to advise the Chamber that the Bureau has recently met, and I'll further advise members that a motion will be lodged at the end of business tonight to allow the Parliament to sit on Friday to conclude consideration of amendments. At that point, I call on the Cabinet Secretary to speak to Amendment 97 and other amendments in the group.
Presiding Officer, I will first address the amendments in my name, then Liam MacArthur's Amendment 98, which all relate to legislative competence. As I've said already, it is the view of the Scottish Government that the bill in its current form is outside the legislative competence of the Scottish Parliament, and we have engaged with the UK Government to address that. This has resulted in a Section 30 order which modifies Schedule 5 of the Scotland Act 1988 to allow the Scottish Parliament to legislate on the identification and regulation of substances and devices for use in assisted dying. This order was approved by this Parliament on the 4th of February and, following the agreement of the Privy Council on the 10th of March, has now become law. The Scottish Government lodged Amendments 97, 102, 103, 110, 111, 126, 127, 128, 130 and 131 in consequence of that Section 30 order. Amendment 110 enables the Scottish Ministers to make regulations which identify the substances and devices for use in assisted dying. If Scottish Ministers identify a device in those regulations, then Amendment 97 enables them to make regulations to require the use of those devices in specified circumstances. The requirements set by regulations made under Amendment 97 are comparable to existing provision in the bill, which requires that an approved substance must be used in assisting death in accordance with the Act. Amendment 111 makes provision for the Secretary of State to regulate such substances and devices. Amendments 102 and 103 remove the existing provision from Section 15 in relation to approval of the substance. Amendments 126, 127, 128 amend Section 28 to provide procedure for the regulations under Amendments 97 and 110. Amendments 130 and 131 make appropriate amendments to Section 29 on interpretation. Without these amendments, as well as those lodged by Mr MacArthur to remove provisions to be dealt with by way of a Section 104 order, it is our view that the bill will not be within the legislative competence of this Parliament and, if passed, may be referred to the Supreme Court or be otherwise legally challenged. This is an outcome that the Scottish Government wishes to avoid, as I am sure do all members, particularly as it is the Scottish Government who bear the costs for such a challenge, not Parliament. Ultimately, it remains for Parliament to decide whether or not to agree these amendments. However, bearing in mind all that I have set out with regard to the bill and the need to bring it within the legislative competence of this Parliament, I strongly urge members to vote in favour of the amendments in my name. Presiding Officer, Amendments 98 and 208 relate to Section 15(1)(a) of the bill, which we have raised concerns with previously. From a practical perspective, this section is very explicit about a registered pharmacist being the only supply route for the approved substance. As such, it does not reflect all potential supply routes, and in particular, all specials manufacturers may be another potential supply route. The current provisions would also not seem to allow for supply under the supervision of a pharmacist, for example, a pharmacy technician preparing, dispensing or assembling a medicinal product. Furthermore, the substances to be used, and therefore whether any use will be unlicensed or off-label, are still to be determined. As such, it is possible that this could be a substance or substances that a pharmacist cannot supply, for example, a Schedule 1 controlled drug, which could make this restrictive definition difficult. In addition, the Scottish Government's view is that Section 15(1)(a) may raise issues of legislative competence, as it may relate to the J4 medicines reservation. Amendment 208 seeks to amend Section 15(1)(a). The Scottish Government's view is that Section 15(1)(a) needs to be removed from the bill due to the operational issues and legislative competence concerns which I have just detailed. That is done through Amendment 98, which I have worked with Mr MacArthur on. Presiding Officer, let me now turn to other amendments within this group on Amendment 11. I would reiterate those concerns we raised at stage 2, namely that it is likely that requiring a registered nurse to be accompanied would be costly and resource intensive. Furthermore, this may set a precedent of health and care professionals being accompanied when they have to attend people in their homes to deliver other services, which would have wider resource implications. Amendment 44 raises several concerns. From a legal perspective, to the extent that provision on management of cases relates to clinical judgment and handling by medical professionals, the Scottish Government's view is that this may raise issues of legislative competence insofar as it may relate to the regulation of health professionals. From a technical perspective, it is not clear what is meant by the management of cases, whether this is a reference to clinical management or to some other form of handling, such as a reporting process. From a delivery perspective, it is the case that this is a reference to clinical. If it is the case that this is a reference to clinical management, it is considered that this would be an unusual. It would be unusual to set this out in legislation. On Amendment 90, the level of prescription proposed may reduce flexibility for professional judgment and could have implications for deliverability, including increased time and resource demands associated with assessments. It is also not clear what would constitute adequate time for a person to consider and ask questions on the information provided. It is the Scottish Government's view that Amendment 99 may raise issues of legislative competence, particularly where the substance provided is a controlled drug, noting that at this point we do not know what substances might be approved. From a delivery perspective, the immediate removal of this substance may not be possible alongside providing necessary patient care. On Amendments 101, 104 and 105, I refer you to my comments in Group 5, where I spoke of the need to remove training provisions from the bill to be dealt with by way of a Section 104 order, should the bill pass. It is the Scottish Government's view that Amendment 106 may raise issues of legislative competence relating to the J4 reservation of medicines, medical supplies and poisons, insofar as it requires Public Health Scotland to monitor the safety and risks of the approved substance. On Amendment 211, there is a lack of clarity around this requirement. It appears to seek to ensure that the assessment is made just before the substance is given and that the person has a face-to-face consultation with the individual. However, it is not clear what a structured review means in practice. A medical practitioner would make an assessment using their knowledge of the person and their clinical expertise. Amending the test to be on the balance of the probabilities does not enhance that or provide any additional safeguard and may indeed weaken it. Amendment 212 would have significant cost implications in terms of clinician time, and I have already noted our concerns around the deliverability of requirements that nurses would need to be accompanied. Introducing an independent registered medical practitioner into the process would further impact on resourcing and the financial implications of provision. On Amendment 213, the Scottish Government would note that, as the approved substance and medical devices are not yet known, it may be too prescriptive to prevent a health professional from providing physical assistance to the person. Likewise, Amendment 217 may be too prescriptive and stand in the way of clinical judgment, particularly if it meant a clinician could not intervene should a person be in distress, as they would not be able to touch the medical device. Amendment 223 seeks to specify who Scottish ministers would consult ahead of making regulations, as set out in Section 15(9). The regulations in question are those provided for in Section 15(8), specifying training, qualifications and experience of authorised health professionals and specifying the approved substance. As I have already set out, these regulation-making powers are being recommended for removal from the bill due to issues with legislative competence, to be replaced in the case of the approved substance by Amendment 110. Amendments 12 to 15, 42 and 43 are all necessary technical amendments, and for the remaining amendments in this group, Presiding Officer, the Scottish Government has no comment other than technical points to be found in the commentary.
Thank you. I now call Liam MacArthur to speak to Amendment 98 and other amendments in the group.
Thank you, Presiding Officer. Conscious of your comments earlier about the need to eat into colleagues' Fridays, I could offer an apology again that My contribution on this group is going to be lengthy given the number of amendments therein, but I will try to be as brief as I can. In that spirit, can I simply acknowledge what the Cabinet Secretary has said in relation to the amendments relating to the Section 30 order, welcome them and urge Parliament to support them. Turning to my own amendments, 98, 42, 43, 101, 104 and 105, given the competence concerns raised by the Government regarding provisions relating to training, qualifications, experience, 101, 104 and 105 remove relevant regulating powers from Section 15 of the Bill. As discussed last night, these matters will be dealt with by way of the 104 order. Again, I repeat my commitment to ensuring that only health professionals with the appropriate level of professional training, qualification and experience participate in any assisted dying service authorised through my bill. Due to the competence concerns, however, the best, indeed the only legally defensible way of ensuring the robust provisions members quite rightly wish to see is by allowing the process agreed between Scottish and UK governments to be followed. As we see opposition campaign groups fundraising to bring legal challenges against legislation already passed in Jersey and the Isle of Man, it's safe to assume the same will happen to any bill passed by this Parliament. There are enough sensitive and complex issues tied up with this legislation of this type without seeking to use it to stress the boundaries of the constitutional settlement. Again, I pay tribute to both Scottish and UK governments. On that basis, I urge members to support Amendments 101, 104 and 105. My Amendment 98 removes subsection 1A inserted at stage 2 from section 15 of the bill. The subsection currently provides that an approved substance must only be supplied by a coordinating registered medical practitioner or an authorised health professional by a registered pharmacist in accordance with the directions of the coordinating registered medical practitioner. As members will know, the bill does not provide for the use of specific substances to assist a person's death. If the Government's Amendment 110 is agreed today, it will provide that Scottish ministers may, by regulations and with agreement from the Secretary of State, identify substances and devices for use in assisting terminally ill adults to voluntarily end their own lives. Whilst we don't know what substance would be approved, it has become clear that Section 15(1)A, which is very explicit, does not, as the Cabinet Secretary said, reflect all of the potential supply routes for substances that may be used, including specials manufacturers. Section 15(1)A would also not allow for supply under the supervision of a pharmacist, for example by a pharmacy technician preparing, dispensing and assembling a medicinal product. It is also possible that the substance or substances could be one that a pharmacist cannot supply, for example a Schedule 1 controlled drug, which could make this restrictive definition difficult. Further, the Scottish Government has confirmed that, in their view, Section 15(1)A would appear to relate to J4 Medicines reservation in the Scotland Act. Regulation of medicines includes regulation of the supply chain, and these are matters which are provided for under the Human Medicines Regulations 2012, which are reserved. As such, the Government are of the view that this subsection be removed from the bill because of both practical and competence issues. Whilst I'm strongly in favour of the role of registered pharmacists as the predominant supply route for approved substances, I accept that subsection 1A may be unduly restrictive, so urge members to support Amendment 98. Amendment 42 inserts reference to an authorised health professional into section 15(4)A of the bill to provide consistency with 15(1), recognising that both a coordinating registered medical practitioner and an authorised health professional may provide a terminally ill adult with an approved substance. My Amendment 43 removes 15(4)C due to duplication. New sections 15(3)A and 4C, both agreed to at stage 2, duplicate each other, and I consider of the two, 3A is preferable as it is wider, stating for the avoidance of doubt that nothing in section 15 of the bill authorises any person to administer an improved substance to the adult on their behalf with the intention of causing their death. This amendment therefore removes subsection 4C. I'll take an intervention from Stephen Kerr.
Stephen Kerr.
Liam MacArthur for giving way. And can I ask him a related question? It does appear in the realm of the other amendments, and that is, in a situation where a healthcare professional is present in the home of someone who has approval to take their own life, if the process goes wrong in any way, can Liam MacArthur say what he would expect the healthcare professional in situ to do? Would he expect them to revive, help the patient, or in effect, euthanize them?
Liam MacArthur.
Can I thank Stephen Kerr for that? I certainly will turn to that and the amendments that very much touch on those points. I think, if memory serves, amendments that Stephen Kerr himself has lodged. I think in answer to his question, though, I would expect the medical professionals to exercise the judgment and the training they have to make the patient comfortable. And those are fairly well established provisions that exist at present. In terms of new subsections, where am I? Yeah, turning to other amendments in the group, Sue Webber's Amendment 9096, 100, 106, 124, 134 and 135 relate to the issue of potential side effects and unintended consequences of using an approved substance. I absolutely support the principle of ensuring people can make informed decisions, and in the bill as drafted, discussions around the assisted dying substance would take place as part of standard practice. Section 7 requires the registered medical practitioner to explain the nature of the substance that might be provided, including how it will bring about death. GMC guidance and professional standards already place a duty on doctors to discuss the potential outcome of different options to help people make informed decisions. However, the amendment as drafted is prescriptive and may unduly interfere with communication between doctors and individuals. I note the BMA warn against placing the weight of legislation behind these conversations. Ms Webber's Amendment 96 requires that such information is recorded in the person's medical record, while Amendment 106 provides for a report to be produced and published by Public Health Scotland, including information on potential complications, adverse reactions or unintended effects. But the bill already requires that the coordinating RMP must record complications and adverse reactions in the patient's medical records and share an anonymised report with Public Health Scotland. The detail set out in Ms Webber's amendment is better suited to clinical protocols than primary legislation, while Amendment 106 also raises legislative competence issues. Nor do I support Amendment 100, which would remove 7A and 7B from the bill. I worked with Stuart McMillan in lodging Amendments 12 to 16. They are technical and arise from changes made at Stage 2. Sections 15.7a and 15.7b address similar matters relating to complications, adverse reactions, etc., arising from the use of an approved substance. 12 to 16 remove the narrower subsection 7b, while requiring the coordinating doctor or authorised health professional to ensure such information is added to a person's medical records, and brings 7a in line with recording requirements provided for under the bill. The Government has made clear that these changes will also allow systems to be designed in consultation with Public Health Scotland during implementation, and I'm happy to support them on that basis. As a result of my Amendment 98, removing Section 15.1a, I can't support Amendments 208, 210 from Brian Whittle, Stephen Kerr's Amendment 222 and Audrey Nicholl's Amendment 224. Regarding Douglas Ross's Amendment 211, the final in-person assessment of a person's capacity and intent, as well as the presence of the medical practitioner at the time of substance is the time that the substance is provided, are two important safeguards within the bill. So while sympathetic to the intention underlying this amendment, the wording, particularly around structured assessments and the balance of probabilities, is not consistent with the rest of the bill, and so it is preferable that regulations and clinical protocols address practice in this area, and therefore I can't support 211. For many of the same reasons, I don't support Mr Balfour's Amendment 212. Protecting vulnerable adults is of the utmost importance, but the bill already includes clear and strong safeguards to ensure voluntariness and capacity, with 2 independent medical assessments, specific checks for coercion and referrals to a psychiatrist and others if there are any doubts around capacity. It's important to recognise that this day would be of profound significance to the person and their loved ones, and so introducing a new clinician at this time may be unduly disruptive without adding any meaningful safeguard. In terms of Sue Webber's Amendment 213, I wholly support the requirement that the final act must be taken by the dying person. However, as drafted, Amendment 213 risks creating unintended barriers to the support that the attending clinician is legitimately able to provide, such as stirring the substance or moving a device to improve the patient's comfort. Guidance developed under Section 23 would provide the necessary clarification and details in this area. Amendment 213, therefore, I feel is unnecessary. In terms of Mr Whittle's Amendment 214, I'm cautious about creating confusion in any of the provisions in Section 15 about who can provide and, if necessary, remove the substance and carry out other functions set out in the section. Section 15 outlines steps, including confirmation of capacity and voluntariness and proper completion of the necessary paperwork. These are vital safeguards and should not be delegated to accompanying health professional who, unlike the coordinated registered medical practitioner or the authorised health professional, would not have undergone the required training and are therefore not inclined to support this. Equally, Mr Whittle's Amendment 221, whose rationale I entirely understand, risks adding confusion. Moreover, if my Amendment 98, removing subsection 1A, is agreed, 221 is rendered unnecessary. While I consider this is covered in existing provisions, I have no objection to Sue Webber's Amendment 215 and 216, which provide that the doctor may provide information and instructions on the use of substance or medical device before they are provided. Ms Webber's Amendment 217, however, is not necessary as subsection 3A and other provisions make clear the substance must be self-administered and not be administered by any other person. I worked with Jackie Bailey on Amendments 10 and 11, which tidy up and improve drafting of the bill. Brian Whittle's Amendments 218 and 219 require that the coordinating medical practitioner or authorised health professional must remain in the same room as the patient until they have died. It was agreed at stage 2 that to balance individual safety and privacy, the medical practitioner would stay in the same room as the person while they take the substance, but then have the option of leaving the room but staying on the premises until the person has died. This was included to allow the person and their family privacy should they wish, but ensure the attending medical professional is still nearby. Stephen Kerr's Amendment 220 is similar, but provides that the medical practitioner must stay with the patient until they have died, or until such time as the practitioner has monitored the patient for a clinically appropriate time and satisfied the adult is no longer at risk of harm from incomplete or failed ingestion, monitoring the patient for signs of distress and taking clinically appropriate steps during that period. And I believe Mr Whittle and Mr Kerr are attempting to achieve broadly the same thing with their amendments, but on balance I believe Mr Kerr's proposed approach is slightly less restrictive and more proportionate. I have no objection to Amendment 220, though note the Government's view that it contains a technical error, but cannot support 218 and 219. Regarding Miles Briggs' Amendment 223, I note that the bill in its current form requires ministers to consult any such persons they consider appropriate before making regulations regarding the training, qualifications and experience required by authorised health professionals. I have no doubt ministers would consult the CMO, the CNO under this process, and as such have no issue with this amendment in principle, but note the Government's view that reference to training, etc. may raise competence concerns and therefore reluctantly cannot support Amendment 223. Turning to Amendments 40 and 70 in the name of Bob Doris, which require ministers to make regulations about the management of cases when the person seeking an assisted death has not died within a timeframe the attending doctor would have expected. As I've noted throughout the bill's passage and as the Health Committee heard at stage 1, recent international evidence shows the instances in which complications arise are extremely small in number. In those rare instances, however, the attending health professional would be expected to respond in a manner consistent with their skills, training and qualification and experience and provide necessary care to that person. Alongside the Government's concern that Amendment 44 may raise legislative competence issues, so while I agree that there may be benefit in the development of protocols in this area, and I'm confident that these will be developed, I would urge Bob Doris not to press and Parliament not to support Amendments 44 and 70. Thank you.
Thank you. I call Brian Whittle to speak to Amendment 208 and other amendments in the group.
Thank you very much, Presiding Officer. 221, 214, 210 and 208 have arisen following concerns from the pharmacy profession. Between stage 2 and 3, I did seek feedback on the amendments that were narrowly turned down, which were meant to future-proof the role of a pharmacist as their role within the NHS evolves. However, the only feedback I have received is that the amendment that was passed at stage 2 will need to be removed for competence. No conversation about how that section 15(1)(a) could be amended at stage 3 for competence, which has given rise to Amendment 208. I think, Presiding Officer, it's becoming quite apparent that the Government are actually putting barriers in place here. I'm actually getting quite disappointed with the lack of interaction the lack of interaction with the government through stage 2 and stage 3. Yes.
Kate Forbes.
I mean, I know this is a free vote and I speak as on a personal basis rather than necessarily on behalf of the government, but I would just push back gently on the idea that government has not engaged in this. On the issues that we're talking about, they are reserved to the UK government under the Scotland Act. And when this bill was introduced, that was not made clear that the regulation of drugs and employment rights were reserved matters, and therefore there would be elements of this bill that would always be legally incompetent, and that is what we are all trying to grapple with. So I just push back gently that it's not the Scottish Government that has either introduced this bill or has determined what is reserved under the Scotland Act.
Brian Whittle.
And I would push gently back again to say this bill has been on the statute books for years. We've been discussing this for years. We've been trying. Sorry, I apologise. This has been in the offing for a long time, and we've been trying desperately through the Health and Sport Committee, through stage 2, through stage. I will in a second, First Minister. Through stage 1, through stage 2, to try and get to a place where this bill could be competent, and only to find out at the last minute that it might not be competent, and the pushback and the lack of engagement from the Scottish Government, which I noted at stage 2. I think is quite disgraceful. First Minister.
I'm grateful to Mr Whittle for giving way, and I've not participated intensively in this debate for obvious reasons, but I cannot have Mr Whittle say what he said about my government, because the government has engaged substantively on this agenda. We have made it clear consistently that the provisions around about medications and about employment rights were outside of legislative competence. That's not a new surprise. The government has put that on the table for a long time. I'm grateful that Mr MacArthur has acknowledged these issues. But Mr MacArthur introduced a bill to Parliament that did not recognise those issues that the government had put on the record. So I firmly reject the accusation from Mr Whittle that the government has not engaged. The government is neutral on the bill, but it has pointed out for some considerable time the issues of legislative competence, and we have sought means of resolving them. That's why there's a Section 30 order. It wouldn't have happened without government engagement on that question. And it's why Mr MacArthur has brought forward the provisions that will result in a Section 104 process, because it has to be resolved or the bill will be legislatively incompetent. And the government has got a duty to make sure the statute book is intact and properly formulated based on the advice available to us. And that's what's been honestly and openly presented to Parliament.
Absolutely, well said.
Well, First Minister, let me tell you, we've been. I know the number of MSPs in this Parliament, and the number of my colleagues in the Health and Sport Committee. And I know how much work they've put into this. I know how much work that Mr MacArthur's put into this, and it's only recently that that's been made available. That knowledge has been made available for us. So I'm sorry, but I disagree intently. And you can protect your government all you like, but that is my opinion on the matter. Mr MacArthur.
Will speak through the chair. Liam MacArthur.
I'm slightly reluctant, given the generous comments that the First Minister's made about me, to push back in the way I'm going to push back. But both the Deputy First Minister and the First Minister have now claimed the bill introduced was legislatively incompetent. Presiding Officer, I'm sure you will testify that this had confirmation from yourself that the bill introduced was competent at all stages, and I acknowledge this at stage 1. There were areas that were Parliament to back the general principles would need to be picked up with the UK Government to ensure competence, namely around use of medicines, medical devices, but also the issues around employment and regulation of professional bodies. So those statements that the Deputy First Minister made was not correct, nor indeed what the First Minister said either.
Brian Whittle. Point of order, Stephen Kerr.
I think the intervention from Liam MacArthur requires that we get some clarity from the presiding officer about the nature of the bill when it was first presented to Parliament, because Liam MacArthur has said that it was the decision of the presiding officer that it was a competent bill to be considered by this Parliament. The Scottish Government are saying something different. But matters of competency in terms of legislative in bills is a matter for the presiding officer.
Thank you, Mr Kerr. As presiding officer, I'm required under the Scotland Act to take a view on the legislative competence of each and every bill at its introduction. And once that statement is made, there is no further role for the presiding officer in commenting on legislative competence. Where members have views on a bill, including whether provisions or the bill raise issues of legislative competence, they have the opportunity during the Parliament's consideration of a bill to make those views known and debate them. But these matters are not for the presiding officer to comment on. The Scotland Act provides for, of course, further checks after a bill has been passed, and whether a provision of a bill as agreed by the Parliament is within the Parliament's legislative competence can only be definitively determined by a court. Brian Whittle.
Thank you very much, Presiding Officer. I welcome Liam MacArthur's intervention here, and I stand by what I said.
Kate Forbes.
I'm very grateful, just purely because I was referenced in Liam MacArthur's comments. And in terms of the 2 points I'd put on the record, it's well known across this Parliament, has been for many, many years, that the regulation of drugs and employment rights are reserved issues. That is why there has been extensive debate about whether they should be devolved or not. So that point is fairly obvious to all members. The second thing is that these are not immaterial issues and insignificant issues to the core bill. The bill cannot exist without these fundamental provisions in it, which is why the Section 30 and the Section 104 has to exist. So I would just again emphasise the fact that the reason that they've been removed in the votes that we've had yesterday, today and tomorrow is precisely because they are not competent and within the responsibilities of this government. And that issue, I think, should be well known across the chamber.
Brian Whittle. Point of order, Stephen Kerr.
This is quite a confusing situation for us. Well, I'm sorry, you may not say so, but we have the First Minister and the Deputy First Minister saying something very different than Liam MacArthur has said, and something quite different than I've understood from the presiding officer. So I'm going to seek your guidance, presiding officer. At the introduction of this bill, was it your judgment and decision that it was a competent bill to be considered by this Parliament?
Mr Kerr, as I already said, I'm required under the Scotland Act 1998 to take a view on the legislative competence of each bill at its introduction, and I did so in this case, and that was my view. Brian Whittle.
Thank you, Presiding Officer. As I said, it was passed competent at stage 1, which goes against what the First Minister says, that they've been open and honest with the way in which this bill has been delivered. And I stand by my assertion that the government have been, at best, unhelpful. First Minister.
Presiding Officer, this is an incredibly sensitive issue for all members of Parliament, and the reputation of my government is being attacked by Mr Whittle, and some comments by Mr MacArthur I think undermine fundamentally some of the actions that he's taken on this bill, and it's important for me that I make this clear to Parliament. Yeah. A Section 30 order would not have had to be sought from the United Kingdom Parliament had provisions in this bill not been outside of legislative competence. It just would not have been required. And my government, in good faith, has sought that Section 30 order to enable Parliament to properly pass legislatively competent legislation by agreement with the United Kingdom Government. Now, we secured agreement for a Section 30 order, and members on other issues will know how keen I am to get Section 30 orders on other subjects where I've been less successful in securing them. But there are other issues that remain outstanding, which is why Mr MacArthur has moved amendments to remove provisions to put them into a Section 104 order, which will be determined by the United Kingdom Government. So it is, should this bill pass this Parliament. But what the United Kingdom Government have said to us is that it's the duty of the Parliament to pass legislatively competent legislation. And the UK Government is indicating to us there is a need for a Section 30 order, which we have agreed to and has been passed by Parliament, and there are also provisions in relation to which will end up in a Section 104 order should Parliament pass the legislation to make it legislatively competent. So I cannot allow Mr Whittle's comments to stand without putting on the record in good faith what the government has done to fulfil its duties to ensure the statute book remains intact and effective, and that legislation passed here is within legislative competence.
Brian Whittle.
Presiding Officer, I do acknowledge the First Minister's assertion, and he knows, hopefully, that I have the greatest respect for him. I am merely stating the quite a lot of anger, actually, at the fact that the amount of work that's been put in, and this could have been brought to us at stage 2 and just wasn't. But I'm not going to labour the point. We've heard the discussion, and I'm sure members in the chamber can make their own mind up as to whether or not the government have been open and honest and helpful in the. Yes,
let's hear one another, colleagues. Stephen Kerr.
Is my friend saying, basically, that it would have been more helpful to the supporters of the bill if the government had said this at stage 1, when we had a full debate in this chamber? Is he saying that the government didn't say that, because the government are clearly saying, as you can hear from the sedentary comments, that they did?
Brian Whittle.
Well, they clearly didn't say that, otherwise the presiding officer wouldn't have passed it as competent at stage 1. However,
let's hear one another, colleagues.
However,
Thank you.
Moving on, presiding officer. Don't make it worse for yourself, First Minister. The bill,
Mr. Whittle, we've been debating, I think, with great courtesy and respect throughout, and let's continue that. And let's hear Mr. Whittle.
The bill, as written, presiding officer, isn't clear on the role of a pharmacist in the process of assisted dying with respect to their scope of practice, which could also risk devaluing the skills of a pharmacist. Now, I asked the pharmacists if they could outline a few of their concerns, and this is what they said, and I quote: "Imagine being a pharmacist, present at an assisted dying, but without the power to act. Imagine the patient or the family member is anxious and asks you for advice about how the substance should be taken, or asks you to confirm that the safety checks have been completed, but you aren't enabled by the legislation to support. This devalues your role as a pharmacist and adds a burden, confusion and potential distress to the patient and/or carer, as they don't get the immediate reassuring answers they are looking for from you. Imagine that the doctor or nurse asks you to hand the substance directly to the patient rather than to them, or asks you to remove the substance at the end of the process, but you can't because you're not enabled by the legislation. Your ability to assist the process is impaired, and your professional skills and experience cannot be effectively utilised, even though these tasks would be well within your competency as a pharmacist. Imagine the doctor or nurse asks you to compound or prepare the substance or prepare the medical device whilst you are accompanying them, but the legislation prevents you from doing so. This puts all the burden on the authorised healthcare professional and doesn't allow your skills to be utilised to add capacity to the process. Imagine, as a pharmacist, you're in the room and you notice the doctor or nurse has made an error. And the legislation is drafted, it is unclear whether you would be able to intervene, which is a huge ethical dilemma. If this leads to a complaint or adverse incident, you may directly be implicated, even though you have no clear role as described by the legislation. Amendment 221 clarifies that role of an authorised healthcare professional could include a registered pharmacist. 214 clarifies that any accompanying healthcare professional, so accompanying doctor, nurse or pharmacist, may provide a terminally ill adult with an approved substance or remove the substance from the premises at which it was provided. 210 clarifies that the authorised healthcare professional may be present for the provision of the substance and not necessarily to provide it. This allows the pharmacist's role in the process to be clearly defined. 208 seeks to address concerns the Scottish Government has about employment law in regard to the above amendment, which was accepted at stage 2 by broadening the subsection to allow for other supply routes as long as they were supervised by registered pharmacists to ensure safe and secure. 218 and 219, the concern there was the liability of medical professionals in the event that something goes wrong. If they're not in the room, they are not immediately aware of any adverse reaction should it occur. 218 and 219 means the medical professional providing the substance must remain in the same room as the patient once the approved substance is administered. Because a medical professional Macy recognise that something is going wrong before everybody else in the room? Presiding Officer.
Thank you. And I now call Douglas Ross to speak to Amendment 211 and other amendments in the group.
So before I thank you, Presiding Officer. Before I get to my Amendment 211, I do want to speak to other amendments in the group to try and bring myself up to speed on where we've been in the last 10 or 15 minutes, because we've now been debating this bill for 10 hours and 38 minutes at stage 3, and there is a conflict of what we've heard in the last 30 minutes of that 10 hours and 38-minute debate. So we've got the Scottish Government on one hand stating that the bill as lodged is incompetent because it requires input from the UK Government. You've got the member in charge saying that the Government were well aware of this from the very beginning, and I'll give way to John Mason in a moment, and you've got the presiding officer ruling that the bill was competent at stage 1. Well, SNP members are saying that's right and get on with it. Then I will give way in a moment because Mr Mason wants to come in first. But the Government made it very clear just a few moments ago they don't think the bill is competent, and the presiding officer said it was competent, which is why we've got to stage 3. And if one of the competency issues is around drugs and legislation surrounding drugs being reserved to the UK Parliament, I don't believe at any point when this bill was consulted on, introduced or debated, anyone ever thought, if it came into law, that drugs would not be used. I'm not aware of any other mechanisms the member in charge or supporters or opponents of the bill have suggested would be used to end someone's life. Therefore, it has been abundantly clear from day 1, line 1 of this bill, which does beg the question of this conflict. I will give way in a moment. I have other members I'd like to take in. We do have a conflict now of what the First Minister has stood up and said and what our presiding officer is telling us as the guardian of this Parliament, and the points made by the member in charge. I'll go through the members as I remember them. John Mason.
John Mason.
I thank the member for giving way. I just wonder if it really matters what happened in the past, and maybe that would be a debate for another time. But we've been here for 10.5 hours. We're expecting to be here till 10 o'clock tonight and 10 o'clock tomorrow night. Would it not agree that we should just get on with the detail?
Douglas Ross.
I'm sorry, I'm shocked at that. Shocked it's come from a parliamentarian who has been here for some time and has served, like me, in both parliaments, and perhaps more shocked that that comment was applauded by some other members. We should at no point with any legislation rush things, let alone legislation that is literally a matter of life and death. And therefore, if there are questions about how we got to this stage, I think it is legitimate for parliamentarians to raise them and debate them and not be urged to just forget about all that, maybe consider it in the future and get on with things just now. I'll give way to Dr Allen.
Alistair Allen.
I thank the member for giving way. I just wonder if he is bearing in mind at the moment that there are many, many people on both sides of this debate who care deeply about it, who are following these proceedings and who are wondering what the last half hour has been about. Yeah, exactly. And does he not think that, given that some of this, such as the reservation of the regulation of the medical professions, has been in the Scotland Act since 1998, that all this outrage is false outrage? We should get back to talking about amendments and get back to talking about the bill that people are interested in.
Well,
Douglas Ross.
Well, first of all, I've been outraged in this chamber many times, and I don't think my current demeanour would be similar to how I was when I was outraged. But Dr Allen is suggesting that people at home will be questioning what the last half hour is about. It's not just people at home. I'm questioning it. I have sat through the last half hour and the comments from the First Minister, which I listened to with all sincerity, the comments from our presiding officer and the comments from the member in charge. That's all happened in the last half hour. It wasn't what I was intending to speak about, but I was invited to speak about my amendments and other amendments in this group where this has come up. And all I'm getting from members of the governing party or former members of the governing party is, don't worry about this, move on. But I can't move on if I have concerns, and I believe people watching at home will have concerns. I'll give way to Claire Hawkey.
Claire Hawkey.
thank Mr Ross for taking my intervention. I'm not going to take up too much time. I absolutely concur with what Dr Allen said. But I can assure him that these things were discussed at the committee stages, and that members were well aware of what is covered by the Scotland Act and what isn't.
Douglas Ross.
I'm not. I understand the committee convener is very clear about what happened at her committee. I sat through some of those proceedings, but the person who started this debate is also a member of that committee and was raising these legitimate concerns, which is why I think we should address them. I'm trying to take people in order, but Mr Briggs was wishing to intervene on that point, so I'll give way to Miles Briggs.
I thank the member. What I find in another side to this whole debate is there was no government minister at stage 2 of this process. So actually for ministers to guide members from both for and against this debate, but those who have brought amendments, brought them back again, and are now being ruled that they are apparently incompetent amendments, shows that the government haven't actually provided that commentary at stage 2. And I think that's important that we recognise that ministers haven't been given that information at stage 2, which is not what...
That's a fair point from Miles Briggs, but is actually not the point I'm making here. That's Miles Briggs' point, and it was echoed by Brian Whittle. I'm getting more to the earlier point in this, where I still haven't got a response. The government think it's incompetent, presiding officer thinks it is competent, and Mr MacArthur, as the member in charge, thinks that the government were not being fully transparent in some of their earlier interventions, he said, because he caveated his own remarks by saying he was worried about saying it based, and I will give way to Mr MacArthur, based on what the Deputy First Minister and First Minister had said. But first of all, Mr Whittle wanted to come in.
Brian Whittle.
No, sorry, I just wanted to stand and say, you know, that we're complaining here that we've been debating this for 10 hours. Some people in here have been working on this for years. I think it's absolutely right we get this with this cleared up, because I am quite angry about it when we get to this stage, because a lot of work has been put into this bill by a lot of people, and we get to the stage now where we all of a sudden discover it might not be competent.
Point of order, Kevin Stewart.
Point of order, Presiding Officer. I feel that you have given an explanation to your reasoning around about stage 1 of this bill. I think that the committee convener has given her view on what happened at stage 2. The government has said right from the outset that it was neutral on this issue. We are now discussing issues when we are dealing with the amendment stage of stage 3. Surely we should stick to the amendment stage at this moment in time. And if there is any discussion to be had about the issues that Mr Ross is raising, that's a matter for the debate at stage 3 on Monday. Could I have a ruling on that, please?
I would only say, as I have previously, that where members have a view on a bill, including whether provisions of the bill raise issues of legislative competence, they have the opportunity during the Parliament's consideration of the bill to make those views known and debate them. And that is currently the situation in which we find ourselves. Douglas Ross.
I'm grateful, and I'm not going to go too much into what Kevin Stewart was saying, but he was suggesting that Mr Ross was making these points. I think it started with Mr Whittle, and then the First Minister, and then the Deputy First Minister, and then the Presiding Officer and the Member in Charge. But as someone who has an amendment in this group, I'm also interested in this. And as someone who is very interested in the passage of this bill, I do not, as some others want to do, look at this at some time in the future and reflect on could we have done this better. We need to get this right now. We need to be sure that what we are doing is legally competent. And I believe, and if others disagree with that, this is fine, but I believe in the course of this evening's proceedings, we have had a direct conflict from what the Scottish Government are saying and what the Presiding Officer is saying. Finally, if he still wishes to come in, I'll give way to Liam MacArthur.
Liam MacArthur.
If it's helpful, the intervention I was making was to clarify the point in response to what the Deputy First Minister suggested about the legislative competence aspects of this bill not being acknowledged at the outset. I've always acknowledged it. It's why I drafted the bill in the way that it has. The convener of the committee is absolutely right that through the scrutiny process at stage 2, these issues were debated and discussed. Amendments were brought forward quite reasonably by other colleagues who wish to see changes made to the bill, and these now need to be addressed at stage 3. And as I've said already, the UK Government and the Scottish Government have worked at pace in order to try to address these, both through the Section 30 order and through the Section 104 provisions. I understand why colleagues, and we debated this at length yesterday, have concerns around Section 104 orders and the issues that are captured by that. But this is what this process is about. Members have an opportunity to vote on the amendments around legislative competence. That's what we've done last night. That's what we've been doing this evening, and that's what we should continue to do for the rest of the evening.
Douglas Ross.
And that is what we are doing. But I don't think we should try to stop debate on these issues. And if some members are absolutely clear in their mind that everything is fine, I respect that, and I agree with their entitlement to hold that position. Where I, as an individual, having listened to part of this debate, have concerns, then I think it is legitimate for me to raise them. If other people disagree with them, that's fine. I have no problem with that at all. But I do think it has been quite a telling moment in this bill, and I think when we come to stage 3 next Tuesday, this issue will be repeated again. But I do want to move to Amendment 211 in my name, because, Presiding Officer, it scarcely needs stated that the moments immediately prior to the administration of the lethal medication is the single most significant moment of the process and the one requiring the absolute highest level of scrutiny and safeguarding. So Amendment 211 replaces the current subjective test of the practitioner being merely satisfied with a requirement for a structured, documented, in-person assessment carried out immediately before provision. So this amendment introduces a clearer, objective legal standard and creates an auditable record, strengthening safeguards against coercion and ensuring that capacity is properly assessed at the most critical point in the process. Now, I listened to the member in charge, Mr MacArthur, when he was speaking to his amendments, and I got the impression that he understood my reasoning behind this, and in some ways he accepted it, but he was urging members not to support it because the language I used in my amendment was not the same language he has used elsewhere in the bill. And I would simply make a plea to Mr MacArthur and those who are following his voting that if that is the only reason not to have an added safeguard in the bill, then I don't think it is a particularly strong reason. And a bill of this complexity and of such importance, I think, could survive, if passed, with some wording that is different, slightly different in some parts than others. The main aim of this is to improve safeguarding, to improve those guarantees, and simply because I do not use identical language in this amendment to other parts in the bill, it does not rule this amendment out in any way, and therefore I would hope that colleagues will understand that this is the very least the seriousness of the circumstances it requires, and that it is our solemn duty as legislators to ensure the highest possible level of safeguarding at what is quite literally the critical stage in the process. So despite the reservations of Mr MacArthur, I hope they can be overcome, and I would urge members for these reasons to support Amendment 211. Thank you.
Thank you. I call Jeremy Balfour to speak to Amendment 212 and other amendments in the group.
Thank you, President Officer. President Officer, before I address very briefly the amendment in my name, I too have listened with real interest in the last 30 or 40 minutes to the interventions by different members. I mean, I think, as someone who has watched this at stage 1 and stage 2 and have followed it quite closely, it would seem to me a lot more sensible for the amendments that Mr MacArthur and the Scottish Government are brought forward at stage 3 to have been brought forward at stage 2, so that these could have been debated by the committee. If it has always been clear that there are sections within this bill that are incompetent, and I think we all understood that, we all understood that this bill wasn't competent, then Mr MacArthur, I think, had a duty to bring these. Now, he decided not to but he should have brought his amendment forward at stage 2 so his clarity. I'll give way to Kate Fox.
Deputy First Minister. Very briefly, my understanding is that there are some amendments that were introduced at stage 2 which actually added to the level of legal incompetence, and I suppose it's something that we all need to have in our minds as we vote at stage 3, that if amendments go through that make the bill incompetent again, these will need to be resolved. Chairman Buffer.
I thank the Deputy First Minister for her intervention. I do accept what she says. I still think we could have taken quite a lot of this bill apart at stage 2, which might have been an easier way to do it. I'll give way to the Cabinet Secretary.
The Section 30 amendments that I'm bringing forward today, Mr Balfour must acknowledge the discussions in the Privy Council process was actually only concluded yesterday.
Chairman Balfour.
Yeah, I've made my point. I move on. If I can move on to the amendment in my name, that is coercion again. We've had long debates on different amendments around this, but by the very nature, coercion is often invisible, and I think it still remains the single biggest danger associated with the introduction of assisted dying. Well, it cannot be eliminated completely, not least because it will often be internal. This amendment would at least provide an element of mitigation at a critically important stage of the process. It does so by requiring an independent registered medical practitioner not involved in the early assessments to observe the patient at a time that the approved substance is provided. I think this is a safety backstop which will give absolute protection but still allow the individual to carry on if he or she wants to do it. The independent practitioner must provide, again, a written assessment that, to the best of their knowledge, the adult is acting voluntarily and without coercion. This adds, I think, clarity and a qualified safeguard, and will replace the reliance on the coordinating practitioner's subjective satisfaction with an independent auditor check. Whether we are for or against this bill, we all want to protect the most vulnerable in our society. And this final assessment, I think, gives that reassurance if this bill is to pass. And I hope Parliament will vote for it in a few minutes' time.
Thank you, Mr Balfour. I now call Jackie Bailey to speak to Amendment 220 and to speak to Amendment 10 and other amendments in the group.
Thank you very much, Presiding Officer. Amendments 10 and 11 follow constructive dialogue between Liam MacArthur, the RCN and me. They are uncontentious, they are sensible, they are practical. So I invite the Chamber to support them, because these amendments would require, where an authorised health professional is a registered nurse, that they be accompanied by the coordinating doctor or another authorised health professional who is a doctor for all stages of the process where an individual is provided with assistance. This is to ensure consistency. Members may recall that an amendment was passed at stage 2 that ensured that nurses acting as the authorised health professionals were not working alone. So these amendments 10 and 11 bring everything into line. So I hope the Chamber will support them. Thank you.
Thank you, Ms Bailey. I now call on Stephen Kerr to speak to Amendment 220 and other members of the group. Mr Kerr.
Thank you, Deputy Presiding Officer. I'm not going to delay me addressing the amendments in my name in this group, except to say that I find it perplexing that the Parliament's lawyers do not insist that a bill is competent when a Cabinet Secretary says, get over it. That's what a Cabinet Secretary has to say, get over it. I will give way in a second. I'm taking a few seconds to offer a thought, and I'm told to get over it. The competence of this Parliament is something that we should all be concerned about as parliamentarians. And if members of the Cabinet don't recognise this as an issue, perhaps it's not surprising that the Scottish Government has ended up in the Supreme Court so often in the last few years. But I will give way to Jamie Hepburn.
Jamie Hepburn.
I mean, it's just to make a simple point. Does the member not recognise that different groups of people can come to different conclusions in terms of the issues of legislative competence? That's not an unusual thing to happen.
Stephen Kerr.
I think it's crystal clear from everything the First Minister said. Jamie Hepburn, I'm sure, was listening to the First Minister as carefully as I was, that it was in his mind, in the First Minister's mind, a crystal clear issue. And I simply wanted to take a second, which is now more than a second, to say that I find it surprising that the Parliament's lawyers allow us to spend so much time in consideration of a bill that is now seen clearly as not being competent as it stood when it was introduced. And as we
Mr
heard...
Kerr, sorry, could I ask you to resume your seat just for a wee second? I understand the presiding officer has already clarified this point, and the process is that when the bill comes to the Parliament, a view is taken at that time. The presiding officer is not thereafter involved in taking a view on subsequent stages of the bill. Thank you. Please resume.
I completely accept that, and I've accepted that from the presiding officer herself when she was in the chair a few minutes ago. It was just... I just wanted to make this point, and it's become something more now. And when the Deputy First Minister says that the bill was even more incompetent after stage 2, then that also leads me to wonder, where is the legal advice that we depend on in this Parliament to provide for good law? So I turn now to my amendments in this group, which are numbers 220 and 222. And up to now, we've been discussing eligibility, safeguards and assessment. And now I think we're getting to the point, clearly, I give way to Neil Gray.
I think, given the commentary that was provided by Government at stage 2, we were well aware of the legislative competence issues of the amendments that were passed there at stage 2, that, as the Deputy First Minister said, took the bill further beyond competence.
Stephen Kerr.
I'm not attempting to doubt either the Cabinet Secretary for Health and Social Care or the First Minister. The point I have made is about the Parliament's legal advisers. Where are they in this to give us the steer that we need? This is not the first time that this issue has been asked. I give way to Miles Briggs.
This intervention, because I think it is an important aspect, and maybe the Cabinet Secretary can tell me, at what point during the history of this Parliament has a Government Minister not attended a stage 2?
So, I think it was an intervention on me, but I, of course, am happy to give way to Neil Gray if he wishes to respond to that.
Cabinet Secretary.
Presiding officer, this is not my bill. I didn't have amendments at stage 2. I didn't have commentary made, but it's the responsibility of the member in charge of the bill, members of the committee, to manage the bill at stage 2, not me.
Stephen Kerr.
I'm grateful to the Cabinet Secretary, and I'm happy to give way to
Miles.
I just think it's an important point, because I fully respect, and I think it's important that the Government is neutral on this bill. But it's not neutral on the legal competencies of this bill, and it should have been advising that. So, another bill which has recently passed through Parliament was my colleague Liz Smith's bill on outdoor education, where the Government again were neutral, but a minister attended that stage 2 to guide members on their amendments. So it's quite clear, a bill like this, you would expect at least the Government Minister to be at committee to raise the points which the Minister is now saying he wants to raise at stage 3 of this process.
Stephen Kerr.
I'm grateful to Miles Briggs for his intervention, and I give way to Douglas Ross.
Douglas Ross.
It was simply to reiterate that point with another example. Daniel Johnson recently had a bill which passed through the Education Committee, and it was a member's bill. So Neil Gray's point that this is not his bill and he had no amendments, the exact same scenario, Jenny Goruth, it was not her bill, she had no amendments and she came to committee at stage 2. So I would reiterate through Stephen Kerr, it may be interesting if the Government could provide this information tonight or through the remaining course of this stage 3 debate. Has it ever happened before where a Government Minister has not attended a stage 2 proceeding on a bill?
Stephen Kerr.
Grateful to Douglas Ross for posing that question. It is an entirely legitimate question, as indeed are all of the questions that we have been raising in the last 45 minutes or so as we consider the stage 3 amendments of this bill, because this is, I think we all agree, the weightiest piece of legislation perhaps this Parliament in its existence has considered, because we are talking about matters of life and death. And now I'd like to turn to the very practical reality of how this law might operate at the moment a life is brought to an end, because now we're not theoretically speaking, we're actually concerning ourselves with what actually happens in real rooms with real people at the most vulnerable moment of their lives. And Amendment 220 addresses what I believe is a serious and potentially dangerous flaw in the bill as drafted. As it stands, a practitioner could leave the room immediately after the ingestion of the approved substance. In other words, at the very moment when a patient's life is ending, medical supervision could be withdrawn. And this should give every member pause. And by definition, this legislation takes Scotland into territory that we've never entered before. I already mentioned the weighty nature of what we are contemplating. And our medical system has never permitted the administration of lethal medication in this way. The question, therefore, that we ask ourselves is quite simple. What happens if something goes wrong? Now, earlier on, I intervened on the member in charge to ask him that very question, because dying is not always predictable. I think Sue Webber made that point very well in her contribution to this particular group. Complications can arise, distress can arise. What is expected to be swift can become prolonged or indeed terribly frightening. In those circumstances, it cannot be right that the person undergoing that process could be left without a trained professional present. And Amendment 220, therefore, requires that a suitably qualified professional remain physically present with the patient from the moment the substance is taken until death occurs, or until it is clear that the substance has not been fully used and the person is no longer at risk. Now, this is the point that I feel leaves us in an uncomfortable place, because it has to do with the use of the word comfortable. Because when I asked Liam MacArthur what he would expect, or what this legislation indeed would expect of a healthcare professional in the situation that I'm describing, if the self-administration of this substance did not work, if it was clear that things had gone wrong, what would the member in charge expect to be done? And he said, and I think I'm quoting Liam MacArthur, and I would welcome a further intervention from him to answer this point in more detail, because I think it merits more detail. He said, make them comfortable. Now, I'm not entirely clear what those words might mean in that situation. Now, I gave him a couple of options. One was to revive and help the person in that moment of extreme distress, and the other was to enable the completion of the function of the administration of the drug, which effectively would be a form, if not indeed the very deed, of euthanasia. Now, I'd be very happy to give way to Liam MacArthur, because I think members, I certainly would welcome some expansion on what he meant when he said make them comfortable, because it is a crucial issue. And I'm grateful that he accepted my amendment 220. I am, but I think that the question I asked him during his contribution remains unanswered, and therefore I am willing to give way if he would please enlighten the Chamber, myself especially, about what the words "make them comfortable" meant in that situation. Will he accept my invitation and make an intervention?
Liam MacArthur.
I did give him a response to the question he asked. There is standard procedures for medics to use their training and experience in the circumstances they're presented with to make the patient comfortable. That is what would be expected in these circumstances. If there is any further guidance that needs to be adapted as a result of the change in the law, I'm sure that will happen. But to try and put things on the face of the bill in the circumstances he's describing is wholly inappropriate, and I'm sure Stephen Kerr would be the first to be jumping to his feet to claim that with a case. We'll be doing this in any other area of medicine.
Stephen Kerr.
I'm not again, I'm really surprised the way that members react to this very serious matter, and I'm grateful to Liam MacArthur for his intervention. But I'm not entirely clear still what he means by that. I assume he means that they would intervene to revive or resuscitate or help the person survive. I give way to Carol Mochan.
Carol Mochan.
If I could intervene on the member. I worked in the health service for 16 years. I know there's other people in the room who will have done the same or have had a family member. And on many occasions, medics will come and speak to us about keeping somebody comfortable or making somebody comfortable. And I think that we have to rely, in this instance, on the experience of the doctors that we'll have, and that kind of information doesn't need to be in the bill, but that we trust these medics so often in incredibly complicated situations.
I'm not trying to introduce anything into the bill. I'm seeking to understand. I'm simply asking a question that creates a quite severe form of moral dilemma in terms of what those words mean. And even after the intervention from Carol Mochan, which I'm grateful for, I'm still really none the wiser. I think this is another area in the bill where there is some dubiety about what the application of the law would mean in any given situation. But again, I express my gratitude to Liam MacArthur for him accepting my Amendment 220. And I now turn to Amendment 222, which addresses a different but equally important issue, and that is the issue of democratic oversight. Because under the bill as drafted, the substances used for assisted dying could be approved through ministerial regulation, with the Secretary of State ultimately holding a veto through a Section 30 order. And I'm grateful to Neil Gray for the way in which he's expanded on exactly what this would mean in practice and the role that would be played by Scottish ministers. But my amendment would require that any approved substance receive explicit approval from this Parliament. The substance used is not a minor technical detail. It goes to the very heart of how this law would operate in practice. It determines the method by which death occurs and the safeguards surrounding that process. If Parliament is being asked to legislate for assisted dying, it should not delegate the most consequential practical decision to secondary legislation of any type. Members themselves should have the opportunity to examine, debate and approve the substance that would be used. Members across the Chamber will approach this legislation from different convictions, and I certainly respect that. But whatever view we take on the wider principle, these amendments address the practical consequences of the bill as it stands. They ensure continuous supervision at the most critical moment, and they ensure that the decisions of such gravity remain under the authority and responsibility of this Parliament. When legislation deals with life and death, those safeguards are not excessive. They are the very least that this Parliament should require.
Thank you, Mr Kerr. I now call Stuart McMillan to speak to Amendment 12 and other amendments of the group. Mr McMillan.
Thank you very much, Presiding Officer. First of all, Amendments 12, 13, 14, 15 and 16 in my name have been submitted following discussion with Liam MacArthur after Stage 2, where I proposed amendments on behalf of the Salvation Army. I do want to thank Mr MacArthur for his engagement and working to deliver these amendments. Amendments 12, 13, 14, 15 and 16 provide technical improvements to the drafting and the tied-up aspects of Section 15. And I do appreciate that Sue Webber has Amendment 100, removing both subsections 7A and 7B, but I ask colleagues to reject that amendment, as my amendments enhance subsection 7A, whilst deleting subsection 7B, which obviously Sue Webber wants to see happen. I also briefly want to touch upon Amendments 43, 98, 101 and 104 in the name of Liam MacArthur. Now, I'm not going to open up what we've been hearing and listening to for the last hour and 20 minutes. But fundamentally, as a process, the Section 104 order is a legitimate process. And it has been utilised in Parliament before, as I touched upon yesterday, with regards to the Delegated Powers and Law Reform Committee, the Movable Transactions Bill and also the Trusts and Succession Bill. Now, there were amendments at Stage 2 and also Stage 3 in those bills. And what we've heard over the last hour and 20 minutes, those concerns were not raised during those particular parts of parliamentary process. And also, the Delegated Powers and Law Reform Committee had unanimous positions on those bills across the chamber. I am saddened by what we have heard over the last hour and 20 minutes, irrespective as to what people are going to do when it comes to the final vote on next Tuesday. But fundamentally, Section 30 orders, Section 104 orders are legitimate parliamentary processes. And I'll leave it there, Presiding Officer. Thank you.
Thank you, Ms Macmillan. I now call Miles Briggs to speak to Amendment 223 and other amendments in the group. Mr Briggs.
Thank you, Deputy Presiding Officer. And I note that Amendment 103 preempts Amendments 104, 105 and my own 223. And Amendment 223 I've lodged on behalf of the RCN, who are neutral on the issue of assisted dying. I note that Amendment 103 would preempt my amendment. However, it is RCN Scotland's position that Amendment 103 is not necessary because Section 15(8) relates to training requirement for devolved health service, not regulation of professionals. The role for registered nurses as authorised health professionals means that if a bill passes, nursing leadership will be vital for ensuring that appropriate protections and training are put in place. And Amendment 223 in my name would require ministers, therefore, to consult with the Chief Nursing Officer, the Chief Medical Officer and others they consist appropriate before laying regulations specifically around training, qualifications and experience that a registered nurse or registered medical practitioner should have to take on the role of authorised health professional. As has just been mentioned, yes. Happy to.
Jimmy Hepburn.
In some ways, I should probably apologise to Miles Briggs because I'm making this intervention with him as the proxy for the Cabinet Secretary, because it only occurred to me in reading the issue again. I'm a little confused in terms of the government's note here, because I've been looking at issues in Section 30 and Section 104 separately, because I think the Section 30 process has reassured me, whereas Section 104 hasn't. I just noticed in the government note here, it says that these matters should be dealt with or can be dealt with as a consequence of the Section 30 order. But the matters that you're touching on sound to me as though they would have otherwise been dealt with through the Section 104 process, because they do relate to training and so on and so forth. So you may not have a perspective on it. I suppose it's really just as much raising the issue as anything else, but if you have a perspective...
Always through the Chair, Miles Briggs.
Thank the member for that, and I suppose this is where the Cabinet Secretary will probably say what he's been saying, and note that the Scottish Government is of a view that this amendment and so many other amendments may give rise to issues of legislative competence. However, the Amendment 102, in the name of Neil Gray, in fact, would remove reference in 15(8) to approved substances. And so my amendment, I think this is a point the member is trying to make, would therefore only require consultation on regulations in relation to training and around authorised health professionals, an issue which ministers should know is fully devolved to this Parliament. So I don't see why this would be outside of the competency of our Parliament. The Delegated Powers and Law Reform Committee has also recommended that a statutory requirement to consult with the Chief Medical Officer should be added to this bill, which is why I brought forward this amendment. And this does precisely what is needed by requiring consultation with the Chief Medical Officer as well. So I move the amendment 223 in my name.
Thank you, Mr Briggs. I now call Bob Doris to speak to Amendment 44 and other amendments in the group. Mr Doris.
Thank you, Presiding Officer. As we all know, occasionally people do not die as expected from taking a lethal substance. I won't have the debate about how often that happens. I'm sure it's very rare, but it does happen. Ingestion of medication is not a reliable route for some people, especially if they're already ill. People may vomit the medication or fail to absorb a lethal or rapidly lethal amount. The person may then not die, or the process of dying may be more protracted and distressing than expected. Amendment 144 would require the Scottish Government to produce regulations on how such situations should be managed. I'll come to the Government's concerns once I put this on the record. Whilst uncommon, this is a scenario of major concern to healthcare professionals. We cannot wish away they have these currently. The role of any clinical professional requires to intervene in such circumstances where complications arise needs to be made clear. This might be a coordinated registered medical practitioner. It might also include staff at the location of an assisted dying where it takes place, or the Scottish Ambulance Service have called to the scene, for example. So it goes beyond the registered medical practitioner. The duties of all such staff in such circumstances needs to be clearer. There must be clear regulations, as far as possible anyway, on what that must or must not happen in such circumstances. I think Mr Kerr was trying to get to that point partially as well during his commentary. Such regulations are important so that the public and families are clear about what a healthcare professional must do or can or cannot do in such circumstances. Yes.
Jamie Green.
Yeah, many thanks to the member for taking my intervention, and it's following on the previous discussion and other amendments about these hypothetical scenarios. I don't actually have a problem with the quite difficult conversations that we do have to have about the substance, about the method, about what happens in the ifs and whens when something goes wrong. I think the question, though, that perhaps some people are battling with is how much of this needs to be on the face of legislation. You cannot in any way, shape or form account for every medical scenario on the face of primary legislation. However, I hope we do all agree that this should feature in guidance and regulations and in normal medical practice. But I feel like if the conversation is dragged solely to we must account for all and every scenario on the face of the bill before we pass it, I don't think that's either appropriate or practical.
Bob Doris.
I associate myself with the comments of Jamie Green. I absolutely do agree with that. What I would note is that this Amendment 44 does not put details on the face of the bill. It's a regulation-making power. But Amendment 70, constitutional amendment, would ensure regulation made under affirmative procedure. Just for clarity on some of the Scottish Government's concerns, they asked about what mean by the management in such circumstances. Would it be clinical care? Would it be other forms of care or well-being? It would be much wider, in my view. What it wouldn't be an administrative process that the Government suggested it could be. As amendments elsewhere in this legislation where the recording of such incidents provisions are made for. So I've not defined management, but it would be management for the well-being of the individual. The reason I've not defined management is exactly the concern the Scottish Government's got in relation to the competency, because of concerns about legislative competence. So therefore, I don't think this will raise issues of legislative competence so far as it may relate to regulation of healthcare professionals, because that's not my intention in this amendment, and I would expect the Scottish Government and consulting on and developing these regulations to have greater certainty, not to bring forward regulations that also regulates healthcare professionals. So if I'm clear we can't regulate healthcare professionals and the Government's clear we can't regulate healthcare professionals, let's pass this amendment and bring forward regulations that are competent.
Thank you, Mr Doris. I call Audrey Nicholl to speak to Amendment 224 and other amendments in the group. Ms Nicholl.
Thank you, Presiding Officer. So my Amendment 224 is a straightforward amendment that seeks to ensure that after a patient dies from the lethal drugs injected, that the doctor's final statement contains sufficient information on these drugs for insurance claims, regulatory review and investigations. Now, this will improve transparency, traceability and accountability. From evidence provided at committee stage on assisted dying abroad, we know that unfortunately there are cases of malpractice, and in these situations it is important for police forces and others to have this basic information available. Dr Ramona Coelho serves on the Medical Assistance in Dying Death Review Committee, which works with the Province of Ontario's Office of the Chief Coroner to identify and address public safety concerns. She was asked to give evidence to the Scottish Parliament reflecting on her experience of reviewing the practice of MAID. She advised MSPs that in Ontario alone, over 400 violations of MAID have been identified since 2018, and that doctors with many complaints to their names have been allowed to continue in their practice. No matter what members' individual position is on the workability of this bill, members will be keen to use all means at our disposal to make it harder for the same issues to be replicated here in Scotland. The recording of information will also be relevant for identifying trends and complications experienced by a patient during the process of dying from lethal drugs. And whilst, unfortunately, there are no studies into the physical experience of patients as they go through assisted dying, we know that there can be a crossover with drugs used on death row, which has undergone research. Due to the combination of drugs used and their side effects, It is suggested that the prisoners are conscious and possibly aware of pain but unable to communicate. Palliative care experts warn that questions remain unanswered as to whether patients dying with the same or similar combinations of drugs under assisted dying would in fact feel any painful sensations. And I'll take the intervention.
Ruth Maguire.
Nickel giving way, and further to what she's saying there about the information that is held on the use of death row drugs, would she share my concern that, according to the Government of Oregon's most recent data, one person took over 137 hours to die, that's 5.5 days, and over half of deaths in Oregon in 2023 took between 53 minutes and 137 hours. Would she agree with me that these facts, probably particularly in light of the uncertainties around what pain is experienced by patients as a result of the drugs or as of vomiting whilst trying to get the drugs down, give a really strong challenge to the notion that all assisted suicides are quick, they're guaranteed to be quick and painless? That's just not a guarantee that we can give to citizens, is it?
I thank Ruth Maguire for her intervention, and in answer to her first point, yes, I do share her concerns, and I do think perhaps there is something around public awareness, for one thing, but also in terms of the lack of research that has been undertaken into the reliability of drugs used in assisted dying. So, for example, recently in the Journal of Law and Biomedical Sciences, there was an article that just set this out very clearly, so I share the members' concerns. So, to conclude, Presiding Officer, whilst Amendment 224 will not address all issues relating to complications, it would make the identification of trends and complications more possible. The recording of basic information on what drugs are used is a necessary step in firming up accountability and prioritising patient safety. And I urge members, therefore, to support this amendment. Thank you.
Thank you, Ms Nicholl. I would say to members that as we are nearing the agreed time limit under Rule 9.8.4a, small brackets C, close brackets, I consider it necessary to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. And I call Ross Grew.
Thank you, Presiding Officer. I wasn't planning on speaking this group, so I do promise to be brief. I just want to address the debate on competency that's arisen from the approved substance issue in this group. And I say this as someone who is still undecided on this bill. I'm not trying to swing the debate one way or another. And I am deeply frustrated that we've got to this point and these issues of competence are still so deeply contested. I would love to know how we got to that point, but right now, I frankly don't really care where fault lies. What's in front of us is a bill and amendments to it. Those should be our only concern. And I do want to emphasise that through the combination of the Section 30 order, Amendments 110, 111, 133 and 133A, we could have a bill in front of us on Tuesday which is competent and which has safeguards on drugs and poisons, on employment protections, conscientious objection, on minimum training and qualification requirements for the professionals involved. At that point, it will be up to members to decide whether or not we believe that would result in a system which is sufficiently safe and operable. But the combination of amendments in front of us, and I'll say it again, 110, 111, 133 and 133A, would resolve the issues of legislative competence and would result in a bill which is safeguarded on drugs and poisons, on employment protections, conscientious objection and minimum training and qualification requirements. I wouldn't want the level of confusion in this debate to result in members coming to the debate on Tuesday doubting whether or not we can have a competent bill. If we vote for these amendments, we can have a competent bill and then we can make a final decision on the core ethical question in front of us.
Thank you, Ms Gray. I call Keith Brown.
Thank you, Presiding Officer. It hadn't been my intention to speak at this point, and I haven't spoken yet in this debate, which after 15 hours was a bit of a record for me, I would say. But I did want to say a couple of words before we decide on the amendments which we're just about to decide on. I have genuine concerns about this bill, and I voted against it at stage one. I recognise, of course, it's a very complex bill, and it's perhaps the most complex set of votes that we've had, in my experience, in 19 years in this place. For my part, I was very keen to listen to others with perhaps more expertise and with different points of view from my own. And in doing so, I also tried to take account of what I believe to be the motivation and judgment of those that are making proposals for amendments. For example, if people have objections on religious or moral grounds, I don't have religious or moral objections to this bill, but I would like to know the motivations behind it. Similarly, if I see unjustified attacks on the government or on the Parliament, that can only, in my view, undermine the judgment and motivation which I form as a view on those making those amendments. In my view, the government has acted with integrity at all stages, and they should not be attacked for doing that. And it's very unfortunate it's happened, because it will leave people like me in the position I'm in, trying to find my way through these amendments with less to rely on as we consider these amendments. Thank you.
Thank you, Mr Brown. And I call Sue Webber to wind up and to press or withdraw Amendment 90. Ms Webber.
Thank you, Presiding Officer. This Group 8 has brought into sharp focus, and I'll not dwell too long about some of the serious competence issues that remain within this bill. Ross Greer has given a very succinct outline of what could be done to resolve that in just a moment ago. But quite frankly, it has been unsatisfactory for this Parliament to find itself here at stage 3 when we're still debating and removing provisions that should have been properly addressed and scrutinised much earlier in the process. And using stage 3 to strip out elements of the bill that should have been addressed earlier is not how careful legislation should be made, particularly on a matter as grave and consequential as this. Because I can think of no issue this Parliament session has debated that carries greater moral weight or demands greater certainty than this. Yet today, well, on Tuesday rather, MSPs are going to be asked to improve. Yes, I will, Mr Gray.
I'll make the same point to Sue Webber as I made to Mr Balfour, that the amendments that, in my name that we're debating here could only have been brought forward at stage 3 because of the agreement that was required to be arrived at with the UK Government only recently concluding. Indeed, the Privy Council process only concluded yesterday.
Sue Webber.
The amendments deadline was quite some time before that statement. But what I'm just saying, Mr Gray, is just outlining how complex this legislation is and the ramifications that this legislation has. And I'm not doubting what you've been doing or indeed what other members have said. I'm here to sum up, and I'm just trying my best to surmise what the debate has been for the last 2 or 3 hours on this group alone. And I don't think it's good enough that we were asked to perhaps approve legislation that will hope everything will just fall into place. That's not the best law, is it? And it's not good enough. And I personally think that's wholly unacceptable. And as I said at stage 1, and I make no apology for repeating it, one mistake in legislation is one mistake too many. Yes, Mr Cole-Hamilton.
Alex Cole-Hamilton.
I'm grateful for the member giving way. Would you recognise that, with a few honourable exceptions in this Parliament, very few of us are clinicians, and it would be, as other members have said, wholly inappropriate for us to hypothecate all of those circumstances in the delivery of the administration of the preparation required to end one's life and ascertain a route or legislate for a route in those cases?
Sue Webber.
I'm quite glad we're not all clinicians, because I'd be upset if all of us were not out here actually seeing patients, maybe in a GP surgery or in an outpatient clinic, because it would be much, perhaps, might make more of an impact on waiting lists there. And I know that's perhaps a slight on your remarks, Mr Cole-Hamilton, but we aren't all clinicians.
Always through the chair, please.
Apologies, Presiding Officer. And, you know, it's our responsibility in this chamber to legislate for the most vulnerable. Those that are not empowered cannot seek out their own information on substances or indeed what steps may be best for them in their dire state of health. And that is why we're here to make responsible law for once. And as I said at stage 1, I make no apology for repeating it. One mistake in legislation like this is one mistake too many. And I also want to talk about something else that's been highlighted, is the stark reality of the process of dying itself. Colleagues across the chamber have spoken candidly about the difference between the rhetoric of a so-called dignified death and the complex, often unpredictable reality of administering life-ending drugs. I mean, Ruth Maguire and Audrey Nicholl have presented some quite horrific and harrowing examples there. And the evidence from other jurisdictions shows that these deaths are not immediate, they're not straightforward, and they are not without complication. And what we've not heard, and I've not been satisfied, I've not heard with. So what does that health professional do? What do they do when they are in someone's home and something goes wrong? Do they revive that individual, or do they euthanise that individual? We've not been given satisfactory answers to that today. And we have to ask those serious questions, and also about the role of that assisting physician. So what happens if things don't go as expected? What happens if the process fails? And what are doctors permitted or required to do if something goes wrong? Yes, Ruth Maguire.
Ruth Maguire.
I thank Sue Webber for giving way, and I take Alec Cole-Hamilton's point that we're not clinicians and we won't spell out clinical practice on the face of a bill. But I just wanted to share an example that will maybe speak to the complexity and why we have to talk through all these things. In a case in Oregon, a drug failed to kill the patient. That patient never repeated the attempt. Now, that might suggest that if the procedure fails, the doctor should try and preserve life. Someone might want to ask a doctor to not intervene. If they were experiencing seizures, if they're vomiting, if their life's in the balance. It's a grey area, and I think that's the point that we're trying to make. I'm not trying to say that the face of a bill will set out the clinical practice, but we have to acknowledge that this is really complicated and complex. It's not just some simple procedure.
Sue Webber.
Thank you indeed, Ruth Maguire, because these are not theoretical concerns. We've heard time and time again they're not. They are fundamental questions about responsibility, legality and patient safety. And the fact that there are so many questions remaining unsolved at this late stage should give every single member pause for thought. And I would like to know if Mr MacArthur agrees with the statement in the Medical Advisory Group report that the doctor be present to ensure the patient dies peacefully, because we've heard of some rather unpeaceful deaths this evening. There are still too many what-ifs surrounding this legislation, and if the member believes that raising these concerns amount to hunting for reasons to oppose the bill, he is mistaken. These are legitimate, necessary questions that must be answered when we are dealing with legislation that would fundamentally change the role of the state, the medical profession and our approach to the end of life. For me, these uncertainties remain far too great, the safeguards far too unclear and the consequences too profound. I urge colleagues across the chamber to think carefully as they vote in this group, and I'll be moving my amendments, Presiding Officer.
Thank you, Mr Webber. The question is that Amendment 90 be agreed to. Are we all agreed? If Parliament is not agreed, there will be a division and members should cast their vote now. The vote is now closed. Point of order, Mary McCallan.
Presiding Officer, I couldn't vote. I would have voted no.
Thank you, Ms McCallum. Normally speaking, we would expect your camera to be on. Maybe that should be borne in mind. And your vote will be recorded. I call point of order, Graham Day.
Sorry, apologies, Presiding Officer. My app's not working. I would have voted no.
Thank you, Mr Day. Your vote will be recorded. I call point of order from Shona Robertson.
Couldn't connect. I would have voted no.
Thank you, Ms Robertson. Your vote will be recorded. Thank you. The result of the vote on amendment number 90 in the name of Sue Webber is yes 53, no 67. There were 3 abstentions. The amendment is therefore not agreed. I call Amendment 161 in the name of Stephen Kerr, already debated with Amendment 150. I would remind members that if Amendment 161 is agreed to, I cannot call Amendment 162 by way of preemption. Stephen Kerr, to move or not move? Moved. The question is that Amendment 161 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 161 in the name of Stephen Kerr is yes 49, no 72. There was 1 abstention and the amendment is therefore not agreed. I call Amendment 162 in the name of Bob Doris, already debated with Amendment 2. Bob Doris, to move or not move?
Moved.
Moved. The question is that Amendment 162 be agreed. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament has not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 162 in the name of Bob Doris is yes 118, no 3. There were 3 abstentions. The amendment is therefore agreed. I call Amendment 163 in the name of Stephen Kerr, already debated with Amendment 150. Stephen Kerr, to move or not move?
Moved.
Moved. The question is that Amendment 163 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 163 in the name of Stephen Kerr is yes 48, no 74. There were 2 abstentions. The amendment is therefore not agreed. I call Amendment 7 in the name of Jackie Bailey, already debated with Amendment 142. Jackie Bailey's move or not move?
Moved.
Moved. The question is that Amendment 7 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their vote now. Vote is now closed. Thank you. The result of the vote on amendment number 7 in the name of Jackie Bailey is yes 19, no 100. There were 5 abstentions. The amendment is therefore not agreed. I call amendment 33 in the name of Bob Doris, already debated with amendment 144. Bob Doris, move or not move?
Moved.
Moved. The question is that amendment 33 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. And members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 33 in the name of Bob Doris is yes 70, no 52. There were 4 abstentions. The amendment is therefore agreed. I call amendment 164 in the name of Jackie Bailey, already debated with amendment 150. Jackie Bailey to move or not move? Moved. Moved. The question is that amendment 164 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 164 in the name of Jackie Bailey is yes 67, no 53. There were 3 abstentions. The amendment is therefore agreed. I call amendment 165 in the name of Bob Doris, already debated with amendment 150. Bob Doris to move or not move?
Moved.
Moved. The question is that amendment 165 be agreed to. Are we all agreed? Yes. Are we all agreed? No. Parliament is not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 165 in the name of Bob Doris is yes 102, no 19. There were 3 abstentions. The amendment is therefore agreed. I call amendment 166 in the name of Bob Doris, already debated with amendment 150. Bob Doris to move or not move?
Moved.
Moved. The question is that amendment 166 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 166 in the name of Bob Doris is yes, 73, no, 44. There were 5 abstentions. The amendment is therefore agreed. I call amendment 167 in the name of Bob Doris, already debated with amendment 150. Bob Doris, move or not move?
Moved.
Moved. The question is that amendment 167 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. Point of order, Claire Adamson.
Thank you, Presiding Officer. It was actually on the previous vote. I'm in the system at the moment, and in the chat it says chat disabled. So I wasn't able to make a point of order in the previous vote. But I wonder if somebody could please explain to me what's happening and how I could do that on the chat next, if it happens again. Thank you, Presiding Officer.
Thank you, Ms Adamson. We will arrange for somebody to contact you to speak to you about that. Obviously, the vote has been recorded, the previous vote, and that will not be changed. I have a point of order from Natalie Don-Innes.
Apologies, Presiding Officer. My app wouldn't connect. I would have voted yes.
Thank you, Ms Don-Innes. Your vote will be recorded. I have a point of order from Edward Mountain.
Presiding Officer, I'd just like to clarify for the record, I unfortunately pushed the wrong button on that vote. I voted no when I would have abstained. I know I can't change it, but I would just like it put on the record, please, Presiding Officer.
That matter is now in the record, but the vote obviously is recorded in the way that the member voted. Thank you. The result of the vote on amendment number 167 in the name of Bob Doris is yes, 75, no, 44. There were 4 abstentions. The amendment is therefore agreed. I call amendment 168 in the name of Bob Doris, already debated with amendment 150. Bob Doris, move or not move?
Moved.
Moved. The question is that amendment 168 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast a vote now. The vote is now closed. Thank you. The result of the vote on amendment number 168 in the name of Bob Doris is yes, 68, no, 51. There were 4 abstentions. The amendment is therefore agreed. I call amendment 169 in the name of Miles Briggs, already debated with amendment 150. Miles Briggs, move or not move?
Moved.
Moved. The question is that amendment 169 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast the vote now. The vote is now closed. Thank you. The result of the vote on amendment number 169 in the name of Miles Briggs is yes 85, no 36. There were 4 abstentions. The amendment is therefore agreed. I call amendment 170 in the name of Miles Briggs. Already debated with amendment 150. Miles Briggs to move or not move?
Moved.
Moved. The question is that amendment 170 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 170 in the name of Miles Briggs is yes 59, no 65. There was 1 abstention. The amendment is therefore not agreed. I call amendment 171 in the name of Fulton McGregor. Already debated with amendment 150. Fulton McGregor to move or not move?
Move, Presiding Officer.
The question is that amendment 171 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 171 in the name of Fulton McGregor is yes 73, no 50. There were 2 abstentions. The amendment is therefore agreed. I call amendment 172 in the name of Paul O'Kane. Already debated with amendment 144. Paul O'Kane to move or not move?
Moved.
Moved. The question is that amendment 172 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. The result of the vote on amendment number 172 in the name of Paul O'Kane is yes 46, no 74. There were 2 abstentions. The amendment is therefore not agreed. I call amendment 173 in the name of Audrey Nicholl. Already debated with amendment 150. Audrey Nicholl to move or not move?
Moved.
Moved. The question is that amendment 173 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. Members should cast the vote now. vote is now closed. Thank you. The result of the vote on amendment number 173 in the name of Audrey Nicholl is yes 71, no 50. There were 2 abstentions. The amendment is therefore agreed. I call amendment 8 in the name of Jackie Bailey, already debated with amendment 142. Jackie Bailey to move or not move?
Moved.
Moved. The question is that amendment 8 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. The member should cast the vote now. The vote is now closed. Thank you. The result of the vote on amendment number 8 in the name of Jackie Bailey is yes 17, no 101. There were 4 abstentions. The amendment is therefore not agreed. I call amendment 174 in the name of Brian Whittle, already debated with amendment 144. Brian Whittle to move or not move?
Moved.
Moved. The question is that amendment 174 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 174 in the name of Brian Whittle is yes 18, no 102. There were 2 abstentions. The amendment is therefore not agreed. I call amendment 34 in the name of Brian Whittle, already debated with amendment 150. Brian Whittle's move or not move?
Moved, please.
Okay, on the basis that that is moved, I now call amendment 34A in the name of Brian Whittle, already debated with amendment 150. Brian Whittle to move or not move?
Moved.
Was that moved?
Moved.
The question is that amendment 34A be agreed to. Are we all agreed?
Yes.
We are agreed. I would then ask Brian Whittle to press or withdraw amendment 34 as amended.
Press.
Press, thank you. The question is that amendment 34 as amended be agreed to. Are we all agreed?
Yes.
The Parliament is agreed. I now call amendment 175 in the name of Paul O'Kane, already debated with amendment 144. I remind members that if amendment 175 is agreed to, I cannot call amendment 35 by way of preemption. Paul O'Kane to move or not move?
Moved.
Moved. The question is that amendment 175 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 175 in the name of Paul O'Kane is yes 36, no 85. There were 2 abstentions. The amendment is therefore not agreed. I now call Amendment 35 in the name of Bob Doris, already debated with Amendment 144. Bob Doris, to move or not move?
Moved.
Moved. The question is that Amendment 35 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 35 in the name of Bob Doris is yes 69, no 46. There were 8 abstentions. The amendment is therefore agreed. I now call amendment 176 in the name of Alistair Allen, already debated with amendment 150. Alistair Allen, to move or not move?
Moved.
Thank you. The question is, that amendment 176 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Point of order, Mary McCallan.
Presiding officer, my app froze again. I would have voted yes.
Thank you, Ms McCallan. Your vote will be recorded. Thank you. The result of the vote on amendment number 176 in the name of Alistair Allen is yes 81, no 43. There was 1 abstention. The amendment is therefore agreed. I call amendment 177 in the name of Jeremy Balfour, already debated with amendment 144. Jeremy Balfour, to move or not move?
Move.
Move. The question is that amendment 177 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 177 in the name of Jeremy Balfour is yes 65, no 58. There was 1 abstention. The amendment is therefore agreed. I call amendment 178 in the name of Paul O'Kane, already debated with amendment 144. I remind members that if amendment 178 is agreed to, I cannot call amendment 36 by way of preemption. Paul O'Kane, to move or not move? Move. The question is that amendment 178 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. This will be a no, I think. The vote is now closed. Thank you. The result of the vote on amendment number 178 in the name of Paul O'Kane is yes 35, no 88. There was one abstention. The amendment is therefore not agreed. I call amendment 36 in the name of Bob Doris, already debated with amendment 144. Bob Doris, to move or not move?
Moved.
Moved. The question is that amendment 36 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 36 in the name of Bob Doris is yes 73, no 43. There were 6 abstentions. The amendment is therefore agreed. I call amendment 179 in the name of Alistair Allen, already debated with amendment 150. Alistair Allen, to move or not move?
Moved.
Moved. The question is that amendment 179 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 179 in the name of Alistair Allen is yes 83, no 40. There was 1 abstention. The amendment is therefore agreed. I call amendment 180 in the name of Jeremy Balfour, ready to debate with amendment 144. Jeremy Balfour, to move or not move?
Move.
The question is that amendment 180 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 180 in the name of Jeremy Balfour is yes 67, no 57. There was 1 abstention. The amendment is therefore agreed. I call amendment 181 in the name of Michael Mara, already debated with amendment 144. Michael Mara, to move or not move?
Moved.
Thank you. The question is that amendment 181 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 181 in the name of Michael Mara is yes 25, no 97. There were 2 abstentions. The amendment is therefore not agreed. I call amendment 182 in the name of Brian Whittle, ready to debate with amendment 144. Brian Whittle, to move or not move?
Not move.
Not moved. I call amendment 9. I call amendment 9 in the name of Daniel Johnson, ready to debate with amendment 150. Daniel Johnson, to move or not move?
Moved.
Moved. The question is that amendment 9 be agreed to. Are we all agreed? The Parliament has not agreed. There will be division. The members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 9 in the name of Daniel Johnson is yes 64, no 54. There were 6 abstentions. The amendment is therefore agreed. I call amendment 183 in the name of Daniel Johnson, ready to debate with amendment 150. Daniel Johnson, to move or not move?
Moved.
Moved. The question is... No, I'm not doing this properly. I beg your pardon. So I now call amendment 183A in the name of Daniel Johnson, ready to debate with amendment 150. Daniel Johnson, to move or not move? Thank you. The question is that amendment 183A be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. The members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 183A in the name of Daniel Johnson is yes 70, no 51. There was 1 abstention. The amendment is therefore agreed. So I call on Daniel Johnson to press and withdraw amendment 183 as amended.
Press.
Press. Thank you. The question is that amendment 183 as amended be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 183 as amended in the name of Daniel Johnson is yes 72, no 51. There were 2 abstentions. The amendment is therefore agreed. I call amendment 184 in the name of Jeremy Balfour, ready to debate with amendment 150. Jeremy Balfour, to move or not move? Is he there?
I'll move on his behalf.
Is he right?
Can I?
Yes, thank you, Edward Mountain. The question is that Amendment 184 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 184 in the name of Jeremy Balfour is yes 50, no 72. There were 2 abstentions. Yes 50, no 71. There were 2 abstentions. The amendment is therefore not agreed. I now call Amendment 185 in the name of Daniel Johnson, already debated with Amendment 150. Daniel Johnson, to move or not move?
Moved.
Thank you. The question is that Amendment 185 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 185 in the name of Daniel Johnson is yes 75, no 47. There were 2 abstentions. The amendment is therefore agreed. I call amendment 37 in the name of Bob Doris, already debated with amendment 150. Bob Doris, to move or not move?
Moved.
Moved. The question is that Amendment 37 be agreed to. Are we all agreed? Yes. Are we all agreed? Yes. The Parliament is agreed, and therefore Amendment 37 is agreed to. I call Amendment 186 in the name of Stephen Kerr, already debated with Amendment 150. Stephen Kerr, to move or not move?
Moved.
Moved. The question is that Amendment 186 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 186 in the name of Stephen Kerr is yes 50, no 69. There were 3 abstentions. The amendment is therefore not agreed. I call amendment 187 in the name of Brian Whittle, already debated with amendment 144. Brian Whittle, to move or not move? Not moved. I call amendment 91 in the name of Sue Webber, already debated with amendment 150. Sue Webber, to move or not move? Moved. Moved. The question is that amendment 91 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 91 in the name of Sue Webber is yes 47, no 75. There were 2 abstentions. The amendment is therefore not agreed. I call amendment 92 in the name of Sue Webber, ready to debate with amendment 150. Sue Webber to move or not move? Moved. Moved. The question is that amendment 92 be agreed to. Are we all agreed? Yes. The Parliament has not agreed. There will be a division. Members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 92 in the name of Sue Webber is yes 46, no 76. There were 2 abstentions. The amendment is therefore not agreed. I call amendment 93 in the name of Ruth Maguire, ready to debate with amendment 144. Ruth Maguire to move or not move?
Moved.
Moved. The question is that amendment 93 be agreed to. Are we all agreed? Yes. The Parliament has not agreed. There will be a division. The members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 93 in the name of Ruth Maguire is yes 74, no 50. There was 1 abstention. The amendment is therefore agreed. I call amendment 188 in the name of Alistair Allen, already debated with amendment 150. Alistair Allen to move or not move?
Moved.
Moved. The question is that amendment 188 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. The members should cast their vote now. Vote is now closed. Point of order, Gillian Martin.
My app isn't connecting. I would have voted yes.
Thank you, Ms Martin. Your vote will be recorded. Thank you. The result of the vote on amendment number 188 in the name of Alistair Allen is yes 84, no 40. There was 1 abstention. The amendment is therefore agreed. I call amendment 38 in the name of Bob Doris, already debated with amendment 150. Bob Doris to move or not move?
Moved.
Moved. The question is that amendment 38 be agreed to. Are we all agreed? Yes. The Parliament has not agreed. There will be a division and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 38 in the name of Bob Doris is yes, 111, no, 9. There were 3 abstentions. The amendment is therefore agreed. I now call Amendment 189 in the name of Brian Whittle, already debated with Amendment 144. Brian Whittle's move or not move?
Not moved.
Not moved. We'll just have a very brief suspension at this moment.